All right, good morning. I will call to order this session of the Supreme Court and welcome everybody to this remote argument. If you are not addressing the court, please make sure that you have muted your microphone so that we don't get any background noise, please. And as I wanted to let everybody know, if you do have a question, please use your icon to raise your hand. I will find a natural point in the argument to rather quickly to cut off counsel to make sure that the judge has an opportunity to ask his or her question. Justice Doria will be keeping time during this argument, and he will show you at 5 minutes, 3 minutes, 2 minutes, and 1 minute. And I just want to make sure, because of how we're doing this, can both counsel see Justice Doria?
For me, it's only if he's speaking.
Let me try this. I won't be speaking to hold up the time, but I can, I suppose, or Justice McDonald could recognize it.
Right.
We'll do the best we can.
We will figure this out. Okay. I apologize to both counsel if it's not a perfect format. We understand that this is a difficult way to do oral argument before the court, but we certainly appreciate you extending yourselves so that we can keep our business flowing and make sure that the people's work and your work is done in a timely fashion. Having said all of that, the first case we are going to hear today is State v. CULBREATH. Each counsel will have 30 minutes to argue. Appellant's counsel can reserve any of that time for rebuttal. Attorney Conlon, are you prepared to proceed?
I am, Your Honor.
Whenever you're ready.
Good morning, Your Honors, and may it please the court. I am Julia Conlon from Sexton & Company, assigned counsel for the defendant appellant in this matter, Jesse CULBREATH. Also here today is Emily Grenier Sexton of Sexton & Company, and if I may, Your Honor, I would like to reserve 7 minutes for rebuttal.
7 minutes.
In the present case, Detective Rykowski's belief that the ends justify the means resulted in conduct that deprived the defendant of his constitutional right not to be a witness against himself. Even at the very beginning of the 9-hour overnight interview in this case, when the defendant asked why the waiver form indicated he was waiving an attorney, Rykowski attempted to distract the defendant by directing his attention to the important right that he could stop answering at any time, rather than extending his right to an attorney. Throughout the interrogation, the police held over the defendant's head that his pregnant girlfriend also was being interrogated and indicated that if they could not determine that the gun belonged to the defendant, everyone in the car, the defendant, his girlfriend, and her uncle, who unbeknownst to the defendant was the confidential informant, would be on the hook.
Thank you, Attorney Conlon. Justice Mullins has a question.
Good morning. I just wanted to clarify before we get going too far. Are you raising only a state constitutional claim, or both the state constitutional claim under Purcell and a federal constitutional claim in terms of the stop and clarify?
We are raising both a Fifth Amendment and a state constitutional claim, Your Honor.
You are raising both?
Yes.
Okay. And on your federal constitutional claim, what's the basis of that claim?
That a reasonable person in the situation would have understood the defendant's question about whether there was an attorney that he could speak to as a request for counsel.
That was the clear, under the federal constitutional claim, you're saying it was the clear request at that point for counsel.
Your Honor.
Is that right?
Yes. Yes.
Okay. Thank you.
Indeed, one of the officers asked the defendant whom they should go after. The others in the car, the defendant's girl, and Rykowski told the defendant that he was not making a threat, but that they would go after his girlfriend for lying. Rykowski used many of the allowable, albeit morally ambiguous, tactics recognized long ago in Miranda v. Arizona, displaying confidence in the suspect's guilt, focusing on why the suspect committed the act rather than on whether he did it, using the friendly-unfriendly ploy, offering legal excuses for the suspect's actions, such as self-defense, minimizing the moral seriousness of the offenses, such by blaming the victim. Indeed, Rykowski said that he would have done the same thing, and relying on dogged persistence, specifically over the course of the 9-hour interrogation, suggesting that the court wouldn't have to teach such a big lesson to someone who admitted what happened, saying that by confessing, the defendant could avoid looking like a monster and offering to call the court once a week on the defendant's behalf.
Counsel, Justice Doria has a question.
Thank you. Help me out with the issue of waiver. I'm not that familiar with what happens when you use the statement. I mean, your client's defense was self-defense, and so part of what he got into was, in fact, the very things that he explained to the detective right after your claim he should have had an attorney. So how does that work? There's this Boyd case that I'm really focused on a little bit. It's a footnote, but
Right.
you might know a little bit more about how waiver works in that context.
Yes, Your Honor. Let me just turn to that page that references Boyd specifically. Okay. So the state's contention that the claim was waived fails for several reasons. First, to waive a claim, the party must know of its existence and reasonable efficacy, and nothing indicates that that was the case here. The violation of the defendant's Fifth Amendment rights and under Article 1, Section 8 was not addressed at trial, and indeed the Purcell decision didn't even come out until after trial. It came out in 2019, whereas the trial here was in 2018. And in Boyd, there was an indication that defense counsel was aware of the existence of a potential claim, where he initially objected to the testimony that was to be presented, asked for a moment to discuss it with counsel, and then when the testimony continued, indicated that he had no objection. We don't have any indication here that there was any thought given to this particular claim, and indeed, in the case of the state constitutional claim, Purcell hadn't been released yet.
That's I mean, it seems it's a odd posture. I get it that Purcell was not out, and so I guess it seems like your claim is you need to sort of reconstruct what might have happened if we knew if your client knew that he had a right under Purcell. That feels habeas-like to me. That how he was counseled or what tactic they. I understand your point to be sort of maybe he would have never even gone to the self-defense route if he just would have put the state to their proof. Is that how it works in this context? I'm just not familiar.
So it sounds to me like now we're getting into harm, and case law does, including Fahey, support the contention that when evidence is admitted that shouldn't have been, you need to consider during the harm analysis the effect on the defense. And here, there would have been no need for the defendant to testify at all because the state would have had no case without the video of the interrogation and the written statement. And indeed, even if they considered the testimony, it was not nearly as damaging to the defendant as the video and the statement, which is why the state focused so heavily on those two pieces of evidence throughout its closing argument. So much so that the harm here is almost akin to structural error in that it was so pervasive. The state primarily used the defendant's testimony to challenge his credibility by showing how it was different than the interrogation and the statement.
Justice Doria, anything further? Justice Kahn is next, and then Justice Keller.
Thank you, Justice McDonald. So my question is precisely also about the issue that Justice Doria raised, that I have similar questions to his. And I read your argument that your position is your client wouldn't have taken the stand, wouldn't have used self-defense, and you just said there would be no case without it. My concern is this: he was arrested the night of the shooting, correct? The gun with his DNA on it is found in a box under the seat where he's sitting. And the police, they don't just find him through other sources. They find him through his girlfriend's uncle, who picks them up because he's hiding because he's nervous about retribution for this shooting. And so is it really accurate to say the state had no case? Because if the state they can explain through the uncle how the gun got in his car. It's the uncle's car. Your client's DNA is on it. They have the ballistics that match. So my question to you is, couldn't part of the reason for not objecting to the video have been that counsel wanted to get the self-defense theory before the jury without the defendant having to take the stand? Because typically you don't get a self-defense instruction until the defendant puts forth evidence. And that evidence can come either from people at the scene or it can come from the defendant. And typically in a situation like this, in order to raise a self-defense claim, a defendant has to take the stand. So if we were to disagree with you that the state had no case, if they have a murder that happens, the gun with the DNA that's used in the murder, and a cooperating witness that says, yeah, I picked him up because they were nervous, he shot this guy, and he brought the gun into the car, doesn't your client then have no choice but to take the stand and explain to the jury that the reason he shot this guy is because he was fearful for his life? So I'm not so sure that it wasn't a strategic decision to let the video in to allow a self-defense claim to go before the jury. It may be that counsel advised them that way and said, don't take the stand. And of course, it's up to a defendant whether to take the stand. But I'm not so sure that that's accurate, that the state would have no case whatsoever, or that there wouldn't have been strategic reasons for letting the tape in to allow this self-defense claim.
A few things, Your Honor. In looking at harm, yes, it is a consideration, the strength of the state's case. Without the statement and video, the state would have been left with a gun found under a seat in someone else's car. The uncle did not testify. So there was DNA evidence indicating that the defendant had come into contact at some point with the gun. That's hardly an overwhelming case. And because of that,
well, wait, I see your point if the gun was found 2 weeks later, if the gun was found 3 days later, but the gun that's used in the shooting is found that night, right? Under the seat where your client is sitting. Yes. Within what, an hour, 2 hours of the shooting? That's very different than a community gun being found 2 weeks later, isn't it?
It is different, Your Honor, but we need to keep in mind that this is a harm analysis and we have to look at the impact of this evidence on the jury. Because there wasn't overwhelming evidence of the defendant's guilt without it, we have to consider the impact on the trier of fact and if the evidence may have had a tendency to influence the judgment of the jury. To say that watching over 7 hours of the defendant's interrogation and having his written statement to the police to consider may have had a tendency to influence the jury's judgment is an extreme understatement. Indeed, the impact of as I mentioned earlier, the impact was pervasive throughout the trial. It was the basis of the state's oral closing arguments and clearly would have had an impact on the jury, which is what we're looking for in a harm analysis. It's distinct from a sufficiency analysis. Whether there would have been enough evidence without it really isn't the issue. We're considering the impact of 7 hours of interrogation and a written statement, and of course it would have impacted the jury.
Thank you. Justice Keller.
Thank you, Justice McDonald. My questions are sort of along the line of the questions that Justice Kahn just asked you. Did the girlfriend testify?
No, Your Honor.
No. So when we think about whether something's harmless, we have to look only at the evidence that was presented at trial. We can't speculate as to whether or not the state might have called the girlfriend or the confidential informant uncle if they didn't have the use of that videotape, correct?
Correct, Your Honor.
Okay, so what you're saying is, if you look at the evidence at the trial and you take away the admissibility of the video and the statement, the confession statement, there was nothing except the gun under the seat with his DNA on it, and we have the forensic. I'm certain there was a forensic match, bullets to the gun.
Yes, Your Honor.
Okay, all right, thank you.
Counsel, I have a question. I just want to be clear. Are you saying that your client wouldn't have had to have testified at all if the statement didn't come in? There wouldn't have been a self-defense?
Sorry.
No, go ahead.
Yes, I would agree that we need to consider the impact of the defense, and what reason would there have been for him to get on the stand if the state didn't have his words throughout the 7 hours of interrogation and his statement to the police. They would have had a gun found in a car with 2 other people that he had touched at some point.
And okay, so your argument is that having a gun with his DNA on it and linked up to the bullets that killed the victim would not have been enough to convict him, that would have been still have reasonable doubt, and so no self-defense argument would have had to been made?
It could have been sufficient, Your Honor, but it wouldn't have been so overwhelming that we couldn't consider the impact all this other evidence would have had on the jury. And even if this court were to consider his testimony in its harm analysis, the defendant's position still prevails because...
It just seems like some of that is speculative, that we wouldn't know that a self-defense argument wouldn't have been made, and we don't know what the state would have done differently if it didn't come in either, right? I mean, they may have called the uncle as a witness. It just seems like there's a lot of speculation packed in there.
I agree, Your Honor, but we have case law like Fahey that says you can consider the impact on the defense, and also even including his testimony and the analysis, the impact of the improper evidence was still harmful. The jury could not have not been impacted by watching this 7-hour interrogation and having his statement in the deliberation room with them.
Thank you. You can continue.
Okay. In light of the inherent compulsion in,
Before you do that, I'm sorry, before you do that, and I apologize for the choppiness of this, but Justice Mullins has a question.
Thank you, Justice McDonald. And part of that is I wasn't quick enough on the draw to get my hand up. So, Counsel, I just want to see if I can fully understand the waiver argument. And I kind of want to try to go claim by claim just to make sure I'm understanding it. So I asked you earlier about the federal constitutional claim, and if you were raising that claim, if I could just ask you, the federal requirement is not the stop and clarify. That's the clearly invoked right to counsel. So in terms of just the federal claim for now, that was something that counsel definitely would have known about. That's not a Purcell issue that came out after this case. It was what the law was before going into this case. And counsel clearly knew what was in the interrogation and said he had no objection to the statement or the video coming in. Why on just the federal claim first is that not a waiver?
It's not a waiver, Your Honor, because it's simply saying no objection in no way indicates that he was aware of and elected to forego a Fifth Amendment claim. That's why we have Golding to review unpreserved constitutional errors. There has to be some indication in the record that there was an awareness of that there's a feasible claim here, and they elected not to pursue it. And we just don't have that by him saying no objection when asked about the video in general.
But doesn't that get to sort of more what Justice Dory was talking about and being a more of a habeas type of thing? Like, we wouldn't presume that counsel didn't know this clear federal constitutional requirement. We would, in fact, presume that he did, unless it's shown through habeas in questioning and evidence that he didn't. We wouldn't presume that his silence was that he didn't know, would we?
We can, Your Honor. Because otherwise there's nothing to distinguish a claim that's simply unpreserved from a claim that's waived. We need that something more in the record, that some indication of an awareness that he didn't just miss in the course of this 9-hour videotape, this statement.
Okay, and you think that's not a habeas type of issue, because in that context, counsel would be able to explain, yeah, I knew about that, but I wanted to get into these other issues and I needed the statement for that. That's usually why we would presume counsel acted appropriately, unless you prove he didn't and give counsel the opportunity to say, yeah, I missed it, I just didn't know, or I strategically didn't challenge that because it would have been detrimental to my defense.
Counsel, before you answer that, you have about 5 minutes left in your principal argument and a couple more judges to ask questions. So please respond to Justice Mullins.
In the habeas context, it would be more to explain why he had a claim that he decided to waive. Perhaps some indication that in a motion to suppress, they were initially seeking to pursue this issue. Then for tactical reasons, he thought it was a bad idea. But when you have nothing in the record indicating any awareness of the issue, it's a Golding issue, it's unpreserved.
Okay. And we don't need anything in the record to indicate that he wasn't aware of the issue. There's just nothing either way. And if there's nothing either way, you would say we assume he didn't know.
Yes, Your Honor. And I would say that's why we have Golding, to review these unpreserved constitutional claims.
Okay, just one more question before you get to other justices. On the state constitutional claim, the Purcell claim, there's no, I don't think the state raises it. The state just addresses Purcell, but Purcell wasn't out when this case was tried. And there's no issue with whether it even applies retroactively or not?
No, Your Honor. I'm remembering correctly, even the appellate court recently, maybe of last week, applied it retroactively, but because it's a constitutional rule, it applies retroactively.
Okay. Thank you.
Justice Eckert, do you no longer have a question?
I'm good. Thank you very much.
Thank you. Justice Keller.
Thank you. Attorney Conlon, in terms of the harm, we would be left with a gun, but I'm concerned about the whole gist of that interview. There is a repetitive, in talking about harm, would you say that the way the interview was conducted enhanced the harm? Because there's a repetitive suggestion over and over and over again by the detective conducting most of the interrogation. We know what happened. We just want your story. We know you did it. We just want your story. If you tell a story now, what do you think about that as enhancing the harm analysis?
And I just want you to know you have about 3 minutes left.
Thank you. Yes, I think precisely because so many of these other tactics, which have been condoned in the past, were used, it kind of just emphasizes the importance of him being properly made aware of the protections available to him. And it really exemplifies why we have these rules, because this is such, I don't want to say coercive, but because there are so many influences at play in custodial interrogations like this, that's why it is so important. In this case, with all of the examples of all the different pressures they were putting on the defendant, really exemplifies how important it is that these rules be followed.
Why do you want to claim that first mention, I don't know if I'm wavering my rights here, he says in the video. Why do you want to claim that that's a clear and unambiguous request for counsel? I think that dialogue falls more under Purcell.
Yes, I agree, Your Honor, for that first comment, that we're not claiming a Fifth Amendment violation there, just state constitution.
So couldn't we say that counsel didn't think, if he knew about the federal law, counsel might very well have thought that was not a clear and unambiguous enough request for counsel for the federal law to apply, correct?
For that first comment?
Yeah, that first interchange,
Yeah,
exchange.
that was,
Yeah.
more setting the tone for how the interview went.
All right, thank you.
Thank you.
And you have about 1 minute left, but Justice Doria has a question, and take as long as you need to answer it fully.
Why don't you, I'll do it on rebuttal. You can wrap up in the next 30 seconds or so. Sorry about that.
Okay. To sum up on the Fifth Amendment claim, the suspect need not speak if the discrimination must were done. Rather, he must articulate his desire to have counsel present sufficiently clearly that a reasonable police officer in the circumstances would have understood the statement to be a request for an attorney, and a reasonable police officer in this case would have understood the defendant's question about whether there was an attorney to whom he could speak as a request for counsel. So Reichowski's failure to stop the interrogation at that point resulted in a violation of the Fifth Amendment, and I will reserve the rest of my Purcell argument for rebuttal because I know I'm out of time.
I appreciate that, counsel. I just want, before the state begins, I just want to make sure that I should have asked this before. Can both counsels see each other?
I think I might need Attorney Oden to speak to see her, judging by how everything else has worked for me this morning. But,
Hi, Attorney Conlon. Can you see me now?
see, your initials are popping. Oh, yeah, I can see you now.
Okay, that's great. I appreciate that. Whenever you're ready, Attorney Oden.
Good morning, Your Honors, and may it please the court. I'm Samantha Oden, Deputy Assistant State's Attorney on behalf of the state of Connecticut. As an initial matter, the defendant waived any claim regarding the admission of his statements into evidence. Defense counsel not only explicitly stated that he had no objection to the admission of the statements, but then used them to support the claim of self-defense. The record demonstrates that this is a tactical decision. The defendant should not be able to pursue a different tactic on appeal now that he's unhappy with the result of his trial. Allowing him to do so would be unfair to both the state and to the trial court.
Thank you. First of all, can you see all of the judges? I knew Attorney Conlon was having a harder time.
Yes, I can, Your Honor.
Okay. Justice Mullins has a question.
Good morning, counsel. I just wanted to ask you also about the waiver argument, and if there's no issue with retroactivity, how would counsel have waived the Purcell argument if the Purcell case hadn't existed yet?
As an initial matter, Your Honor, counsel is presumed to be competent. And in Purcell, this court talked about how the state constitutional claim was really an open question at the time. And so counsel doesn't need to know that the challenge would be correct, or that she would prevail, or defense counsel would prevail on the claim. But because it was an open question at the time, even if Purcell wasn't in existence, counsel still could have made that objection.
But don't we also have case law that counsel is not required to be prescient? They don't have to make a claim that doesn't exist yet in order to be effective. So it seems like that's a more difficult road to hoe for waiver, but I could be wrong, and I'm hoping you could explain to me that if the stop and clarify, as we kind of cleared up in Purcell, did not exist at the time this trial was going on, how would we say counsel waived that constitutional claim?
Because even though counsel wasn't required to pursue that claim as a matter of effectiveness, counsel still could have pursued that claim because it was an open question at the time to preserve that issue. And by saying no objection, counsel basically gave up the right to challenge the evidence at all on appeal.
For any and all purposes, ever?
Yes, Your Honor. Yes. The record demonstrates that this was a tactical decision, and this wasn't any inadvertence on the part of counsel. Even the cross-examination of Detective Reichowski, defense counsel gets into, actually asks about this response to the defendant's sort of ambiguous request for counsel. So defense counsel definitely knew about the factual basis of that claim.
Justice Mullins, do you have any follow-up questions along those lines?
No, I'm all set. Thank you.
Thank you. Justice Keller is next, then Justice Ecker.
Thank you, Justice McDonald. Attorney Odom, what makes it an open question at the time? Were there trial court decisions that had ruled that the state constitution required something different? Was there an appellate court opinion that had ruled that way?
I believe, Your Honor,
other states, other federal districts, circuits?
I believe it's in the Purcell decision, Your Honor, about how, I think it was a Connecticut decision back from the 1980s, I want to say, if I can just look really quick. Right, so it's State versus Pinder, 250 Con 385. Prior in Purcell, this court said, prior to our decision today, it was an open question whether this court would require a more protective rule under our state constitution.
That's a 1985 case?
1999, I'm sorry.
1999? Okay.
Yes. But again, it would be unfair to both the state and the trial court to allow the defendant to now seek a different tactic or strategy on appeal.
Did the defendant make any kind of motion to suppress that statement, those statements?
No, Your
Prior
Honor.
to trial? No? Okay, thank you.
Thank you. Justice Ecker is next, then Justice Doria.
Thank you. Good morning, counsel. I had a question on the waiver, and then I had a question on the merits. Both of them have to do with maybe soliciting the state's help in drawing some difficult lines. On the waiver point, the line I have in mind is a difficult one between the failure to preserve on the one hand and the waiver. It's been talked about. I guess what I'm wondering is whether you have any thoughts about how to distinguish the fact that he said no objection, he or she said no objection. I mean, if something's offered and the judge looks at, I guess you say either I object or I don't object. So I'm not sure that doesn't strike me as an affirmative waiver necessarily, at least of a claim that's based on a constitutional theory that hasn't yet been articulated by the courts. And using it to your advantage, you make the best out of the situation. So lawyers make the best out of the situation. I'm not sure that's how we can draw the line either. Do you have any suggestions on that question? How to draw that line?
Your Honor, I see it as it's waived if it's tactical and it's golding if it's inadvertent. So here we have the trial court basically flagging a possible issue, inquiring of counsel, saying, hey, do you have any objection? That sort of triggers counsel to really look at the evidence and say, do I have any objection to this? It's not any inadvertence on the part of counsel.
Okay. Yeah, I understand that. I have to think more about it, but that's helpful. On the merits, this is my question. In a way, I feel like these Miranda rights or many of these rights of the accused, it's like the IRS, it's like the Internal Revenue Code, right? The rules get made and then the police figure out ways to, get their tax exemption, or the defendants figure out ways, and then we're on to the next step. So here we have a situation where you've got, at least now, this stop and clarify rule under the state constitution. And I know the police officers didn't know it at the time, but even if they did, the question in my mind is what happened here that bothers me is the editorializing by the police officer accompanying the inquiry. So there's a difference between saying, wait, you're talking about a lawyer now. Do you want a lawyer? You have a right to a lawyer. That's Miranda, that's clear. Do you want a lawyer? Make your decision. There's a difference between doing that and then subtly sort of advocating for why a lawyer isn't such a great idea. like, that's fine, but you understand, then our relationship is over. We stop talking. If you want a lawyer, that's completely up to you. Absolutely fine. You're entitled to a lawyer, but then it's over. I can't help you anymore. Okay, so what's your decision? So, and my question for you, it's a long one, but I appreciate your patience. Does the state think that's okay? The editorializing, or wouldn't it be better just to have a rule that says stop and ask the neutral question?
It would be better practice to stop and ask the neutral question. And that's what Detective Rykowski tried to do in this case. His initial response was, you know, when the defendant asked, is there someone that he could talk to, like an attorney or something? He asked, we do, yeah, is that what you want? And it was only in response to the defendant's questions that Detective Rykowski was honestly answering the defendant's questions, basically giving him, you know, we would have to stop this interview right now.
Okay, so you're saying that basically the defendant asked for the advice.
He was,
the
yeah.
defendant also, I mean, so that's, I mean, it's a, okay, I get that. It's a strange rule. I particularly didn't like the reference to the lawyer and the money, you know, that I think was really unfortunate. Would you agree with that? I mean, you know, the idea, well, yeah, you know, that's a lawyer, but they need to earn a living. And so they're going to tell you not to talk, and that'll end our relationship. Since you asked the question, I'm answering it. Isn't that troubling?
I do think it's somewhat troubling, but I don't think that it's improper. And I know that Purcell does talk about, it does provide protection for if officers are actively trying to convince the defendant to not invoke his rights. But in this case, it didn't rise to that level.
Justice Ecker, are you finished? Justice Doria is next, and then I have a question.
Yeah, I mean, along those same lines, you know, there's subtleties that you can't, well, maybe you can try to determine whether he's trying to prevent him from invoking. I mean, everybody in the room is rooting for this, for him not to say the magic words, whatever those were under Davis, and now what they are under Purcell. But when the one sentence that bothers me the most is, it's not going to tell me why or who or what reason. So there's kind of, you know, hey, then we're not going to be able to talk any longer. That's true. That's, you know, that's the stop part, and then whatever you do to clarify. But the, you know, as Justice Secretary says, it's the advocacy. Well, what do you say to that? You know, giving him the you know, this is why it's not going to work in your interest.
I think, again, it was in response to the defendant's question. I think he asked, you know, what then? Even after Detective Rykowski said, well, we're going to have to stop this immediately if you want your attorney. And it doesn't rise to the same level as what happened in Purcell, where the officers were really trying to convince the defendant, you know, if we stop this interview now, if you don't get your side of the story out, you could be going to prison for the rest of your life.
Yeah, but they, you know, now understanding, look, we all know Purcell wasn't the rule at the time. So this was probably good, you know, by the book, you know, police work, but we're viewing it through this lens now. I mean, I think you're right. Maybe it's responsive to what he said, but I mean, tell me whether you think this is the right analogy. If this was just provocative small talk in the back of, you know, he's in the back of the cruiser, or he's not quite yet in custody, or he is in custody. I mean, don't we have cases that say, you know, the police officer just got to clam up at some point and not provoke, you know, through subtlety or overtness, things that could be seen as interrogation in that case, or here you're not in the stop and clarify safe harbor. You're off doing something else. Does that sound off base to you?
No, I just think that the circumstances of this case are different, because the defendant really, you can tell that he's still trying to decide whether he even wants to invoke his right to an attorney. So, and he keeps asking these questions, and Detective Rykowski, he's answering honestly, basically setting forth, this is your chance to give your side of the story. but really it's leaving it up to the defendant, and he's not really trying to convince him one way or another. At least I don't see it that way, as trying to actively convince him one way or the other.
Any follow-up questions, Justice Doria? All right, well, my question is along the same lines, I guess. Let me approach it from a different perspective. Before the detective left the interview room, does the state maintain that it was that the defendant had already clarified definitively whether he wanted an attorney or not?
It's that and the combination of, so it's him choosing not to stop and taking that break, plus the fact that once he got back into the, once Detective Rakowski returned to the interview room, the defendant reinitiated conversation about this, about the investigation.
Well, he reinitiated a conversation about his girlfriend. So that's a conversation. But is it the state's position that before the detective reinitiated his interrogation, there was a definitive answer from the defendant about whether or not he wanted an attorney?
Yes. I mean, I do think that—
When did that happen? Where's the definitive answer?
Well, Detective Rakowski kept giving the options. You know, he kept saying, we can stop now, we can stop now. And then he asked, do you want to take a few minutes? And by choosing to take a few minutes rather than stop, the defendant expressed his desire to—
Is it really the state's argument that under Purcell, and I understand the detective didn't have it at the time, but is it really the state's argument that the fact that the defendant continued a conversation inquiring about his girlfriend was a affirmative decision that he no longer wanted an attorney? Is that really the argument?
Yes, Your Honor. He made clear that he wanted to continue this conversation or this interview with Detective Rakowski, and he was okay with doing so without an attorney. So
silence is acquiescence. I mean, since he didn't reassert the claim that he wanted an attorney, the state's position is that's a clarification that he doesn't want an attorney.
Yes, Your Honor, because Purcell doesn't require this explicit statement. Defendants can express their desires through their actions, just like when, even when a defendant unambiguously requests counsel, if he reinitiates the conversation, that act in itself expresses a desire to continue without counsel present.
Okay, thank you. Justice Kahn is next, then Justice Keller.
Thank you, Justice McDonald. My questions are along the same line of Justice McDonald and Justice Doria. Given that he gave him a few minutes, wouldn't the more logical interpretation be that he gave him a few minutes to think it through? And wouldn't it have been far better? And I know Purcell wasn't around, and I understand your argument on that. And I also understand your argument on waiver, but wouldn't it have been better if Detective Rakowski had said, okay, so do you want to continue or do you want to stop?
Yes, Your Honor.
I mean, it seems like it would have been a very simple, if I could finish my question, it would have been a very simple clarification at that point. And it wouldn't have left in doubt whether his silence was acquiescence and wanting to go forward. And I guess that's what troubles me, is that the conversation continues after you need a few minutes, but then there's no clarification, if you will. Wouldn't that have been better? Of course, your answer is going to be yes, but why isn't that interpretation of what occurred a logical one?
So yes, Your Honor, I do think it would be a better practice for Detective Rakowski to have come back and asked, and that probably would have been the case if Purcell was the law at the time. But and
now assuming, excuse me, assuming that the initial question, am I wavering? He's looking for an explanation of what is that phraseology in the written Miranda rights means, assuming that passes sort of the federal and state muster. But what happens the second time assuming we were to say that's not clear clarification, then would the state's position be that the first half of the interrogation, where he denies even being in the location, comes in, but not, let's say the second half doesn't come in, the state would still be able to use his denial against him at a trial, correct? His denial of even being in the location.
Yes, Your Honor, and that could be used as consciousness of guilt evidence against him, because then you have, you know, the physical evidence tying him to the crimes and him lying about it.
Anything further, Justice Khan?
I am. Thank you, Justice McDonald.
Thank you, Justice Keller.
Just quickly, when they took the break, you know, I have a real problem with the fact that when the officer came back, I thought the break was for him to think about whether or not he wanted to talk to a lawyer. The officer comes back, doesn't even mention that subject, and the use of the girlfriend bothered me, and that's when he comes back and starts talking about. And there's all this dialogue about her being pregnant. You're going to have a family. Tell your story now so she doesn't have to lie for you, because she's very close to being charged with hindering prosecution. I mean, I just felt that there was a real effort to avoid any talk about whether or not he should have an attorney, and a lot of pressure on him to talk now or his girlfriend was going to be in trouble. Do you agree?
Those were Detective Rykowski's responses, but again, it was in response to the defendant's questions. So as soon as Detective Rykowski returns, I believe it was the defendant who started asking about his girlfriend. It wasn't Detective Rykowski initiating that conversation about the girlfriend and how she was pregnant.
Well, that went on repetitively throughout the whole interview. The suggestion that the girlfriend might get in trouble. And you need to save her now. That kind of thing.
Right.
On the waiver, I know, I can't remember the name of it. I know I was on a panel on the appellate court last year where we had a waiver issue. And in that case, the trial court did more than say, do you have any objection? The trial court actually suggested to counsel that this might not be and something that counsel wanted to have admitted. Kind of like, really, you're really not going to object to this? I mean, don't you think we need something more than just a failure to object?
I don't think so. I don't think so, Your Honor, because if you think about all of the types of claims that the trial court would have to canvass defense counsel on, it would be a burden on the trial court to think of it's sort of advocating at that point, trying to issue spot for counsel. So I think it's enough for the trial court to ask, you know, are there any objections? That gives counsel the time to think about it and make that tactical decision himself.
And then in State versus Rosa, which was an appellate court case I authored last year, there was a suggestion that a Batson claim had been waived. And I believe in looking at there was just nothing to suggest that the attorney had any idea he even had a Batson claim. He thought he had a good grounds for a petition for a new trial. What's your reaction to the way we decided that case in the appellate court? State versus Rosa, Tyrone Rosa.
I don't think I'm aware of that. I don't think I've read that case, Your Honor.
Yeah, I know the other side cited it in their reply brief. So, okay, thank you.
Justice Doria.
Oh,
you're muted.
Your Honor.
Thank you. I've asked this question of the state before, and so I don't. I'm not sure if you're going to know. The reason I say I'm not sure you're going to know is Golding has been around a long time, but there was a pre-Golding era. I remind Justice Mullins of occasionally, but it was. We used to have State versus Evans, and what was classically Evans reviewable, which kind of morphed into Golding, is newly announced constitutional rights. And there would be, there would be challenge sometimes. It was challenging sometimes for there to be enough of a record to vindicate that newly announced constitutional right. But I don't remember those cases speaking about waiver. So you might be right on the federal claim that, you know, either saying no objection or then using the evidence constitutes a waiver, or maybe the record ends up being faulty. But if you don't know about Purcell, just like, you know, the officer didn't know about Purcell, why is it to say, I mean, let me put it this way, and I'm sorry for the long-windedness. If they had objected, if counsel had objected, that was coming in because that was the law. So what's the difference? It's just, I think Attorney Collins' point is it's just an unpreserved claim.
Well, if counsel had made that objection, then it wouldn't have been waived for appeal. I'm not sure if I'm understanding the question.
But that's Golding. That's Golding all the time. You fail to object. And so I guess I'm saying is I'm wondering where the idea of a newly announced constitutional right went, if you know, or maybe the state can help us in some other case between Evans and Golding. That always seemed to be part of, you know, unpreserved cases came because of newly announced constitutional rights. And I guess I mean, if you're sticking to your point that no objection means even for new claims that haven't been announced yet, I'm just not sure that's going to turn out to be the law. But do you think?
I'm not aware of the Evans decision, so I can't really give a good answer on that.
Anything further, Justice Doria? All right, I think you have just about 5 minutes left, but let me ask you let's assume for the purposes of this question that we disagree with the state on the substance of the Purcell matter. I'd like you to address briefly harmlessness and if you can squeeze in just a couple of comments about the prosecutorial impropriety claim, I'd appreciate that.
So first, with respect to the harmlessness of the defendant's statements, the gun charges weren't disputed at trial. It was undisputed that the defendant was the person who shot the victim. So really the issue of harm only comes down to the manslaughter conviction and whether those statements were damaging to his claim of self-defense. You know, this court can't just take the defendant's testimony out of consideration for the evaluation of harm. There's no legal authority to support that kind of analysis. In this case, it would be pure speculation because there was no objection. So there's nothing in the record to show that the defendant made his decision to testify because that evidence came in. And engaging in that kind of analysis would essentially permit gamesmanship on the part of the defendant, allowing him to pursue one strategy in trial and another on appeal. And so with respect to the claim of self-defense, during the state's closing, it primarily used the defendant's statements for two reasons: to show that the defendant did not see the victim with any weapon and that the defendant did not leave or retreat during the altercation. But the defendant's testimony demonstrated this as well. And just as one example, the state was quoting the defendant as saying that the victim came at him with clenched fists. And in his testimony, the defendant also testified that there was a short scuffle with the victim lunged at him and took a swing. Let
me briefly interrupt you. Is it the state's position that based on the other evidence that existed, it was inevitable in some fashion that the defendant would have been forced to testify on self-defense based on the other evidence exclusive of the statement?
I don't think he would have been forced to testify on his own behalf, but I don't, it would have been hard to see. It's hard for him to say now that he wouldn't have presented this claim of self-defense knowing the strength of this other physical and circumstantial evidence.
And if you could briefly address the prosecutorial and impropriety claims.
Yeah, there's really only two impropriety claims that I specifically wanted to address. The first one was the state's argument that the defendant didn't have to travel on Judson Street that night at all. I do agree that that comment is improper, but it doesn't rise to the level of a due process violation. There was an objection by the defendant, which the trial court effectively sustained. The court made clear to both the state and the jury that the argument was improper by instructing the prosecutor to move on to the time of the incident itself. The state did move on and otherwise focused on the time of the incident. And then the trial court's final instructions to the jury on self-defense made abundantly clear what the jury could properly consider. And then the second argument that I wanted to get into was the state's argument about the motive to lie. Even if this argument implies that one of the witnesses had lied, it still doesn't rise to the level of a Singh violation because it's not telling the jury that it must find that Rykowski lied in order to find the defendant guilty. It's really not referring to guilt or innocence at all. And it's more like the prosecutor's argument in Stevenson, which this court found to be proper.
Thank you. Justice Khan.
Thank you, Justice McDonald. On the issue of harmlessness, and I understand your argument was because there was no objection to the statement coming in, we can't speculate that the reason he testified was because the statement came in. So I have a two-part question. Was there any other witness other than the defendant who could have raised the self-defense claim? In other words, did any other witness testify about a self-defense claim?
No, Your Honor.
Okay. So in looking at harmlessness, we should remove the evidence that came in and the use of that evidence. So if we remove his statement, his self-defense statement, and remove the cross-examination during his testimony about that self-defense using his prior inconsistent statements, had the defendant testified at trial without the jury hearing his prior statements or being cross-examined about them, the state would still be able to cross-examine him about his duty to retreat, why he couldn't have retreated, and all the elements of self-defense, correct?
Correct, Your Honor.
So not the entire cross-examination of his claim of self-defense wouldn't be thrown out the window, but rather those portions that he previously said that contradict him. The state would still be able to cross-examine him about whether his claim of self-defense was reasonable, whether he could have retreated safely before using a weapon, whether the alleged victim had a weapon or not, correct?
Correct, Your Honor. And the testimony that the defendant was inconsistent on between the statements and his testimony were really small details, like such as where the location of the jacket was on the fence, what he was doing in the neighborhood. He gave more details at trial to the fact that he was dealing drugs in the neighborhood that night. So it was basically the inconsistent statements went to the credibility of his trial testimony, not really his self-defense claim.
Thank you. Your time's up, but you can share a concluding comment if you'd like.
Well, the state respectfully requests this court to affirm the trial court's judgment then. Thank you, Your Honors.
I appreciate that. Thank you. Attorney Conlon, you have your 7 minutes.
Thank you, Your Honor. I want to take a moment to revisit how we got to Purcell. It was just last year that this court concluded that under our state constitution, there are additional protections for suspects even when they make equivocal requests for counsel. The decision cites concerns for suspects who, because of fear, intimidation, linguistic skills, etc., will not clearly articulate their right to counsel, even if they want a lawyer. This court reasoned that those who feel intimidated or powerless are more likely to speak equivocally, even where no ambiguity is intended, and that certain suspect or quasi-suspect classes, particularly women and ethnic minorities, more commonly rely on indirect speech patterns. Accordingly, even if the requests in this case were equivocal under Purcell, Rykowski was required to cease the interrogation except for narrow, clarifying questions about the suspect's desire for counsel. Although responding to the defendant that it was fine if he wanted an attorney, Rykowski then told the defendant that they would have to shut this down, let the cards fall the way they will, that the evidence won't tell them why the incident happened. Rykowski further told the defendant that if he got an attorney, he probably wouldn't let him speak to him because they have to make their money and do their thing. You know what I mean?
Counsel, let me ask you, I'm struggling with trying to understand or appreciate the defendant's harmlessness argument. Could you illuminate that a little bit for me?
First, Your Honor, it's imperative to remember that the standard for harmlessness, first of all, it's the state's burden to prove harmless beyond a reasonable doubt. And the question is whether the evidence may have had a tendency to influence the judgment of the jury. If so, it cannot be considered harmless. And clearly listening to 7 hours of this 9-hour interrogation and then having the written statement as well is going to influence the jury. It's going to be very impactful. Even
let me ask you, I just don't know the record well enough. Was a continuous 7 hours of the video played for the jury?
Yes, Your Honor.
So it wasn't redacted or edited in any fashion. It was just raw footage for 7 hours?
Yes, I believe there were certain gaps where nothing was happening and they would skip those gaps. So of the 9 hours, I think just over 7 were played for the jury.
Thank you. Justice Doria.
Yeah, I want to ask you briefly about one of the prosecutorial misconduct claims. It's the issue of the motive to lie. And it's not clear to me what the prosecutor was referring to. What was there that the detective might have had a motive to lie about that would have pitted his credibility against the defendants? What do you understand them to have been at odds about?
I believe the argument was intended to be that you can believe Officer Rykowski because he has no motive to lie, whereas the defendant does have a motive to lie.
But about what? About what? I mean, is everything that Rykowski did, wasn't it on videotape? What could he have lied about?
Well, he did give his impressions during his testimony that the defendant's explanation of self-defense wasn't consistent with what he concluded from the evidence.
Okay.
Let me ask, are you done, Justice Doria? Let me ask you, I wasn't quick enough on my feet. So if the 7 hours was played for the jury, is it the defendant's position that, well, first of all, I assume there would have been no problem with the state showing the first 3 hours and 4 minutes until the invocation of the attorney issue arose. Is it the defendant's position that that there was not enough information already gleaned in the first 3 hours of the interview that would support the conviction?
Yes, Your Honor, it was after the invocation of the right to counsel that the real confession began and the denial ended.
Okay, I mean, I just watched that really relevant part. I didn't watch the first 3 hours. So when we do, you're confident that there will be nothing in that first 3 hours that would, with all inferences in favor of the state, that would support a conviction?
Nothing comes to mind, Your Honor. And I believe that's why Detective Rykowski was so insistent that the defendant seize this opportunity to tell his side of the story.
Thank you. Justice Doria, how much time? I don't think she can see you.
Just under 2 minutes.
Okay.
So in short, instead of doing what he was supposed to do, Rykowski asked the defendant if he wanted to take a few minutes, that it was up to him if they continue. The defendant accepted the offer of a few minutes, but then Rykowski returned and resumed the interrogation as if nothing had happened. So first he tries to talk the defendant out of getting a lawyer and then resumes the interrogation as if nothing happened. And clearly, for Fifth Amendment purposes, he knew the defendant was asking for a lawyer because he tried to talk him out of it. Just briefly, in terms of reviewability, in order to waive a claim, the party must know of its existence and reasonable efficacy. Nothing indicates that was the case here. Next, the particular protections were personal to the defendant. Trial counsel could not have retroactively waived a claim to them, particularly when they've been invoked by the defendant. Even if it could be considered waived, it wasn't induced and should still be reviewed under Golding. Alternatively, this court may invoke its supervisory authority to review this case as it presents exactly the type of circumstances directly implicating the perception of the integrity of our criminal justice system.
Thank you. Let me interrupt you just briefly. Justice Ecker has a question.
Counsel, I just had a question, based on your last comment about the interview and Officer Rykowski's response. So your position is that waiver, and I don't know exactly the words we used in Purcell, so you'll tell me if it's in Purcell or if it would require an extension of Purcell. The waiver can't be implied by conduct. Is that your position, that the clarification needs to be explicit? Is that your position? Because there's a plausible argument that at least certain conduct could be taken appropriately as a waiver, or as a decision, a choice.
I just want to make sure I have the language right, Your Honor. So Rykowski was required to elicit from the defendant a clear and unequivocal expression of a desire to continue without counsel. I'm trying to think an example of how that could happen without words. I can't right now, but it certainly didn't happen in the present case. He asked about his girlfriend, and Rykowski proceeded as if nothing had happened, rather than clarifying as he was required to do under Purcell.
Thank you.
Counsel, your time is up, but please feel free to provide any brief concluding remarks that you'd like to.
Just in sum, Your Honor, we have a Fifth Amendment violation, absolutely clear in violation of Purcell here. This is exactly the type of case that merits supervisory authority review if the court does deem it waived. I just want to point out one thing, because there can't be habeas relief. It's imperative that this court address the claim, because you can't find ineffective assistance of counsel if the claim didn't exist at the time. And for harm, again, because the persuasive evidence of the 7 hours of the interrogation and the statement clearly would have impacted the jury, and therefore the state cannot establish its burden of showing harmlessness beyond a reasonable doubt. Thank you.
Thank you very much. I want to thank both counsel. This was very difficult under these circumstances, and both did an exemplary job. I really appreciate your advocacy today. With that having been said, the Supreme Court will stand in recess until our 11 o'clock case.